Hello and welcome. Thanks for joining us. If you give us a couple minutes, we'll just wait here a couple minutes for a few more people to get on. So just 1 or 2 minutes, please. Okay, I think we can get started. We're excited to be here, and we're going to get started today with Mary Meg McCarthy, Director of the National Immigrant Justice Center.
Great. Good morning. I'm Mary Meg McCarthy. Welcome to all of you. I am the Executive Director of the National Immigrant Justice Center, and as you will hear today, NIJC is unique in that we provide direct legal services and use that to engage in systemic reform through our advocacy, impact litigation, and public education. And today we are very excited to present to you NIJC's recently released report, A Legacy of Injustice, Ending the Criminalization of Migration. This report addresses family separation, institutional racism, and due process violations, and documents how the administration has exacerbated these problems during this global pandemic. I want to congratulate my colleagues, Jesse, Dorian, Ellen, Tara, and Heidi, who have all been critical to the success of this report and to today's program. But also, we are deeply grateful for the immigrants who have been impacted by this, who have been so generous and courageous to share their stories, some of which you will hear today. Again, thank you for joining us. We hope you will continue to participate in our webinars that are upcoming and learn more about what's happening in this very, very challenging time for immigrants and refugees. I now turn it over to Ellen Miller, NIJC's Pro Bono Manager. Thank you.
Thanks, Mary Meg. And yes, echoing Mary Meg's excitement for today's program. My name again is Ellen Miller, and I'm the Pro Bono Manager at NIJC, and we are very excited to launch our new series of NIJC's Policy Corner. Every first Tuesday of the month from 12 to 1 p.m. Central Time, where we will be giving you updates on current important immigration or issues in immigration policy and how it impacts our clients and their access to legal protections. So there are quite a few, over 200, and so we are all currently muted. And for those of you that are not familiar with the webinar format, you can type your questions in the chat box or type your comments in the chat box. We'll monitor those throughout the presentation and be sure to leave time at the end to answer them in a Q&A. We also invite you to check out the resources that are attached in the handouts. There you will find the report for which we're gathered here today, and you can see some of the visuals a little bit more up close. You'll find a list of resources that show NIJC and our partner organizations' efforts to decriminalize migration, and also a list of opportunities for ways that you can get involved and continue to support NIJC. We will be sending these materials as well as a recorded presentation at the end or in a follow-up email after the presentation. So we are coming to you today from coast to coast. Mary Meg has already introduced some of our presenters, but you're going to hear from Jesse Franzblau, Senior Policy Analyst, who's in DC, Dorian Ediger-Seto, who is one of, and you're also going to hear from Jordan Rosinski, who is a communication strategist currently sitting in El Paso, Texas. So we're excited to get started. I'm gonna move this forward. And for those of you for whom it's your first presentation or introduction to the National Immigrant Justice Center, this is about who we are. To explain, now expand just a little bit, at NIJC, we're a broad-based immigration legal service provider, headquarters in Chicago, and we have 5 offices in cities across the country, like I mentioned, in DC, San Diego, and also 2 offices in Indiana. We serve over 10,000 non-citizens every year. And really, this is only possible through our expansive pro bono network of over 2,000 immigration pro bono or just pro bono attorneys that exponentially increase our impact in policy initiatives, direct legal services, and larger litigation efforts. So what is different about NIJC, again, is the high volume of direct legal services and high volume of litigation and policy work. These components all come together so that we can share the stories and experiences of our clients and our lawyers to influence litigation and policy goals. But as a whole, but I know that today we have a lot of information, and so I'm going to turn it over to my colleagues, Jesse and Dorian, to talk more about this great report and the impact that it's having. Jesse and Dorian?
Thanks so much, Ellen. Thanks so much to my colleagues, to Dorian, to Mary Meg, to Heidi Altman, Jordan Rosinski, to Tara Tidwell Cullen, who all played a really essential role in the production of this report. Really happy to be here today to discuss. So today we're going to be discussing the laws that are used to prosecute people for their manner of entry and re-entry into the US. We're going to be sharing stories of people who NIJC represents and people who have suffered rights violations and abuses as a result of such prosecutions. We're going to be discussing how these laws have been used to violate the rights of people and fuel mass incarceration along racial and ethnic lines. Lastly, we're going to be discussing ways that everyone can get involved and help, and then open it up to questions and answers. So during the Democratic presidential debate last year, so we see on this next slide, we see some pictures of the presidential debates that took place. So we heard a lot of discussion about decriminalizing migration, and this really became a mainstream topic last year. We heard phrases like, we need to repeal 1325 and 1326. So what were they referring to? So these are provisions of law that make it a crime to enter the country without permission. That's section 1325 of US Criminal Code. And then there's section 1326, which makes it a crime to re-enter the country after deportation or prior removal order. And so our report looks at this historical backdrop of the structural racism that has helped shape these laws. It discusses how lawmakers that were aligned with eugenicists and segregationist pursuits first advanced the laws that criminalized migration in the early 20th century. So here we have pictured a white supremacist South Carolina senator named Coleman Livingston Blease, who advocated openly for segregationist policies, even advocated openly for lynching. He introduced the law criminalizing unauthorized entry and reentry into the US, largely to please nativists at a time of really heightened anti-immigrant sentiment, including members of the Ku Klux Klan. Senator Blease's law, his bill became law in 1929. And so fast forward to 2018, 2017, and 2018, a lot of people were first exposed to the concept of these prosecutions because they were the centerpiece of the administration's harrowing family separation policy that shocked the nation and the world's conscious in the spring and summer of 2018. In announcing the zero tolerance approach towards people crossing the border, the administration ensured that asylum-seeking parents would have their children ripped away from them as they arrived at the border so that the parents could be prosecuted. The separations that ensued were in many cases permanent. And so while the family separation policy is technically ended, as we know in this report, we really highlight the sense of urgency that continues, and in large part are urging members of Congress and the public to not lose this sense of urgency that we felt the summer of 2018. We also discussed how the pandemic has exposed the systemic harms and excessive waste that's really inherent to this complex infrastructure behind migration-related prosecutions. We talked about how these prosecutions have put thousands of people at risk, keeping them locked up while serving their sentences and awaiting hearings during the pandemic. Our report addresses how these federal laws criminalize unauthorized entry and reentry into the US, how they inflict undue harm on migrants, and we emphasize that repealing these laws is really an essential step towards ending systemic injustices, reducing mass incarceration, and protecting fundamental human rights. So in our next slide, we discuss, we look at these charts that show the pattern of how these prosecutions have increased over the years. And in our report, we really discuss how immigrant rights advocates and communities have been advocating for repeal of these laws that are used to criminalize migrants. For decades, people have been advocating for the repeal. And NIJC, of course, supports these calls, and our work with their San Diego office has really helped build a growing body of evidence illustrating that repeal is long past due. We're part of a coalition that supports legislation called the New Way Forward Act that was introduced in December 2019 in the House of Representatives, which for the first time would repeal the laws that are used to prosecute people for entry and reentry. And so we can see in these charts, so for the last 20 years, the US government has prosecuted violations of these laws that we're discussing today in greater number than any other type of federal offense in the US. These prosecutions have been used over the years to advance racist policy agendas. We discuss how a major surge in these prosecutions came in the post 9/11 restructuring of the immigration enforcement landscape in the early 2000s, and discuss how the Bush administration created a program called Operation Streamline in 2005. Under this program, the Department of Justice and Homeland Security prosecute people en masse, upwards of 80 people at a time in one day. These assembly line prosecutions continued during the Obama administration and continue today. And then, of course, the Trump administration has really weaponized these laws to new heights, using them to block asylum seekers and separate families. So there were more than 105,000 people prosecuted for entry and reentry violations in fiscal year 2019. That was up nearly 50% from 2017. So we see how these numbers continue to grow. These prosecutions contribute to about 10% of the federal prison population at any given day. Now, my colleague Dorian is going to discuss how these prosecutions really function and what agencies are involved.
Thank you, Jesse, and thank you all for being here today. My name is Dorian. I'm an attorney in our San Diego office here, and our goal really in our San Diego office is to serve exactly these clients. So we have a collaboration with the Federal Defenders of San Diego, and when they are assigned cases of people who are charged with these crimes, they call us so that we can work with individual clients to make sure that they understand what's going on, what their options are, and that access has really enabled us to develop a huge body of evidence, as Jesse said, to kind of explain why all of this is really unfair. So I interact with these systems on a daily basis down here at the border. And I guess from the outset, I would note that these systems are just complicated. There's multiple federal agencies, there's different areas of law. It's about deportation, it's about the criminal system, everything's kind of a mess. And so if you're confused by this wonderful flowchart that Jordan made for me, you're in really good company. I talk to people who are being targeted directly by these laws, who are explicitly being impacted by these systems every day. And the overwhelming sense that my clients express to me about these prosecutions are, firstly, that it feels very racist and degrading to be targeted under these laws. And secondly, that it's just really confusing. And so even this flowchart, which we're trying to kind of demystify the process, is potentially quite overwhelming. And if you're listening on the phone and you want to see this flowchart I'm talking about, it's on page 4 of our report as well. So kind of to walk you through how these actually work on a day-to-day basis, I'm going to introduce you to Oliver. So Oliver is an NIJC client. He's one of my clients. He is a young man from Honduras. He's an enthusiastic recreational soccer player. He's really close to his family, and he's lived through pretty intense violence in Honduras, which he fled last year. So Oliver, he tried to ask for asylum at the port of entry when he got to Tijuana, but he was turned away. He was told that he would have to wait in line, which is a separate discussion, but part of a program that essentially this administration has used to restrict the flow of asylum seekers into the US and to make it very difficult to even ask for asylum at the port of entry, which is what people are supposed to be able to do under international law. So feeling pretty unsafe in Tijuana, Oliver jumped the fence so that he could ask for asylum. About 5 minutes after he entered, he was arrested by the Border Patrol. I think he actually might have waved them down, and he asked for asylum. But they didn't write that down in their notes. Instead, they took him to their station, took his biometrics, his fingerprints, his eye scans, and they processed him. So during this processing time, they basically make 2 decisions. And this happened in Oliver's case, but it happens in every case. So if you could go to the next slide. So back to our flowchart. So first they decide how they're going to process a person's immigration case. So when somebody is apprehended at the border, this usually means putting somebody into a process called expedited removal proceedings, or for people who have prior deportations on their record, a process called reinstatement of removal. Both of these are summary removal processes that basically enable the arresting agency to act as judge, jury, and executioner, as long as somebody's case fits into the pretty basic criteria, letting them put folks into these systems. People subject to them are removed without ever getting to see an immigration judge at all, unless they firstly express fear of return to their country. Secondly, that fear is actually written down and noted down by the agent who's processing their case, which, although it's required by law, often doesn't happen. And then third, they pass a screening interview called a credible fear interview or a reasonable fear interview with an asylum officer who's satisfied that they have a colorable claim to protection in the US. And usually all of this happens when somebody is detained, though it's our position that that is not necessary. The government doesn't always agree with us, though. So that's the first decision, which is kind of what deportation track are you going to be on? And as you'll see in the flowchart, there's that yellow line kind of around 2 of the boxes. That's actually the whole immigration process in this chart. Everything else is the federal criminal process. So in Oliver's case, they decided to put him into expedited removal proceedings, so denying him the right to see a judge unless he passes through the screening process. And then they kind of moved to the second decision. So the second decision is whether or not you'll also be referred for federal prosecution, which, as you might have guessed, also happened to Oliver. So the moment that this decision to prosecute is made, the immigration processing pauses. It doesn't stop. So these folks are all subjected to basically 2 legal systems, no matter what. The immigration processing pauses. People are transferred to federal criminal pretrial custody. So usually to facilities run by the US Marshals, which is a division of the Bureau of Prisons, I believe. And they're arraigned in federal criminal court. So sometimes arraignments happen on the regular criminal docket. So in a lot of 1326 reentry felony cases, people will kind of come through the court system on the same timeline and with the same situation as people who are charged with other federal crimes. Sometimes, and especially in 1325 cases, so it's usually a misdemeanor improper entry charge, The prosecutions happen in mass group hearings. So what Jesse was talking about with Operation Streamline, where anywhere, between like 30 and 80 people are called into a room at the same time. They're almost always shackled, and they're asked to plead guilty one by one. Oftentimes, people will only have, depending on what district you're prosecuted in, and it does look really different across districts, but oftentimes people only have like 15 minutes with their lawyer before they end up having to go to court to plead guilty. So it all happens really, really quick. So basically, with Oliver, what happened is he was referred for 1325 prosecution. He spent some time in pretrial criminal custody until he was actually able to get assigned a criminal bond to pay a bond to get out of custody. His case was actually quite unusual. Usually when somebody pays a criminal bond, DHS comes and picks them right back up again and starts the deportation process all over again. In Oliver's case, and in some of them in our San Diego district, they actually hold off on doing that until the whole criminal prosecution is over. And so in his case, DHS didn't take him back into custody when he paid his bond. So he was able to live freely in the community while he was waiting for his trial. So that's when I met him, and we were able to take advantage of that time. And I helped him to apply for asylum. And then, so he was scheduled for his final hearing. He was set to go to trial. And on the eve of trial, like after business hours were closed, his public defender got an email from the prosecutor saying that they were going to be willing to dismiss his case. So Oliver walked into court knowing his case was going to be dismissed, but also knowing that the Border Patrol would probably arrest him, which is exactly what they did. So they sat in the back of the federal courthouse waiting for his hearing to be over. And as soon as the criminal proceeding was over, they, in the courthouse, arrested him and took him back into detention, even though he had showed up to every single one of his court dates. So he was taken back into custody. He spent over a week in short-term Border Patrol custody. And then he was transferred to a longer-term ICE detention facility in order to wait for his credible fear interview. He ended up spending about 4 months in detention, first waiting for his interview, then waiting for the results of his interview, then waiting to see a judge to review the results of his interview. And during that whole time he was in detention, he entered detention right as COVID-19 started to make its way through the jail and prison and detention system in the US. And he actually was detained at Otay Mesa Detention Center, which was one of the first ICE facilities to have like a really, really big outbreak. And so he was actually detained in the very first housing unit that got put onto lockdown after a guard tested positive. Throughout this whole time, ICE refused to release him. So he had to wait until he had gone through the whole CFI process to see a judge before he was eligible to ask for a bond to get out of detention. Ultimately, he ended up having to pay $7,000 to get out of detention, which was $2,000 more than the criminal bond he had been assigned, even though he complied impeccably with conditions of his release in his criminal case. The immigration system felt that that was not enough to guarantee that he would show up to court to fight his asylum case. So I'm going to wrap up soon because I know that we're throwing a lot of information at you. But Oliver's case happened a pretty typical 1325 case does. I will note especially on the border, I guess. So both of these federal crimes can be charged against people who are living on the interior of the country, not just at the border. It happens more frequently with 1326 cases. That's the reentry case. And oftentimes illegal reentry cases, that kind of more serious felony charge after a deportation, if you reenter, you can be prosecuted with that. It carries really, really high sentences as well. So basically, so a lot of those arrests happen on the interior of the country. And so everything that you've heard about DHS's kind of creepy surveillance systems, ICE raids in people's homes and workplaces, oftentimes 1326 prosecutions come along with that apparatus. And they're also often used as kind of a pretext and as a justification to justify some of the more nefarious types of surveillance activities that DHS does. And we do, so our partners at Just Futures Law and Mi Gente have been doing a bunch of work on the way that the tech industry and DHS work together. And so if you're interested in that piece, I suggest that you check out all of the stuff that they've uncovered. So I'm going to pass it back to Jesse to talk a bit more broadly about, you know, with these cases, how they're processed. I've kind of explained how they're processed, but to pass it Jesse to talk about our findings from the report.
Thanks so much, Dorian. So starting in around June of last year, so for the last year, NIJC carried out an investigation involving field research in border regions in Texas, Arizona, and California. As part of this process, we interviewed people like Oliver. We witnessed people dragged into court for these mass hearings, for Operation Streamline hearings, shackled in chains, people exhausted from the horrible conditions in freezing cold CBP facilities. One after another, people shared their stories, their desperate need to be with their children and family at any cost. And the categories of violations that we generally documented were the permanent separation of families, the routine violations of domestic and international asylum law, the violations of basic due process protections, and the persistent dehumanizing and racist treatment by federal officials. We observed ongoing family separation still taking place as a result of such prosecutions in places such as the Southern District of Texas. We observed Operation Streamline court processes, as Dorian described, where people have very little time with an attorney, have very little understanding of what the legal process is, raising serious concerns around no and involuntary pleas. And we observed consistent prosecutions of asylum seekers without them giving the rights that asylum seekers are supposed to have, and without even being asked questions if they had feared to return to their country, and not given the right to be referred for an interview to explain their fear. So on our next slide, one of the individuals who we spoke with, named Luis. So Luis was brought to the US from Mexico as a baby in 1979. He became a lawful permanent resident in 1986, but he was deported in 2003 after he had a run-in with law enforcement over an incident related to theft. But he returns multiple times to try to escape threats of Mexico and to reunite with his family. He essentially had no home in Mexico, no family. He lived under a bridge in Tijuana for a time. He was targeted by police and corrupt networks because he was essentially a foreigner in that country. And in 2017, after he had returned to try to be with his family, he was detained by CBP, by Border Patrol, and then referred for prosecutions for illegal reentry. And he's now serving a 6-year sentence for this conviction, even as he appeals that conviction on constitutional grounds. And he wrote us for prison. He said, "I didn't return to the States because I wanted to. I did it out of necessity. My daughter, my only child, who was a resident, what was I supposed to do? Stay in Mexico and brush it off?" So that is just one of the many stories of individuals who we spoke with who have been so drastically impacted by these types of prosecutions. On our next slide, we discuss a bit about how these prosecutions fuel mass incarceration along racial and ethnic lines specifically. So undocumented immigrants who are referred for prosecutions for unauthorized entry and reentry, they're shuttled between the criminal and immigration systems. Both of these systems, where racial profiling and discrimination are really common to both. And as a result, communities of color are disproportionately impacted, as data on US prison population, race, and citizenship demonstrates. And so, as Dorian mentioned, the sentences that are attached to these prosecutions range from up to a few days for illegal entry, but up to 20 years for people who have prior interaction who are convicted for illegal reentry. And as a result, nearly 25,000 people are held in federal custody at any given day in Bureau of Prisons population, and also in US Marshals custody. So importantly, misdemeanor prosecutions for unauthorized entry are largely conducted along the US southern border. And as Dorian mentioned, unauthorized reentry, felony prosecutions occur throughout the US, impacting thousands of people every day across the country. In our report, we document how entry and reentry prosecutions fuel privately run prisons that are built exclusively for non-citizens, referred to as criminal alien requirement facilities. And in our report, we look specifically at one of these facilities in Michigan that's run by the private prison company Geo Group. And we discuss how these facilities have long been plagued by scandals and serious abuse. And this Michigan facility in particular, where coronavirus has spread, people inside this facility have gone on hunger strike, accusing prison guards of segregating the facility by race. And there in May of this year, the company Geo Group and Bureau of Prisons tragically confirmed the first death of someone inside this jail because of coronavirus. And so now we'll pass to Jordan Brzezinski, my colleague, who will share another story of an NIJC client who has gone through these type of prosecutions.
This is Dorian. I'm actually going to intro Alexiss a little bit just to give a bit of context to her story. So Alexiss is another young NIJC client from Guatemala. And she was one of the very first people I met in my current position. She was already working with NIJC. And at the time, she was experiencing intense harassment from guards in pretrial U.S. Marshals custody over her gender presentation. But during our visit, she smiled through all of her tears, and she was singularly focused on her goal of asking for protection in the U.S. She knew before going back into immigration custody that immigration authorities don't always listen to people when they say that they're afraid to go back. And so she had actually been practicing with her friendly cellmates, asserting her fear by doing role plays with them. And as you'll hear in a second, DHS agents actually ignored her. So Jordan's going to read. We were unable to get Alexiss live today to give her testimony, but we do have a video with her testimony and on a blog post on her website, which I believe is in the materials. But Jordan is going to read some of it to us.
It took me a long time to arrive at the border. The journey was terrifying, and many I traveled with died. A Border Patrol agent picked us up. I asked them for water. I even knelt, asking him to give me water, but he didn't want to give me water. We were taken to the Hilera. It's something that's a living hell, to tell you the truth. It's something really ugly. They give you food that you can't even imagine, but in that moment, the food is so delicious because no one has food in their stomach because they haven't eaten anything. In the Hilera, an immigration officer asked me what I came to do in the United States, why I didn't stay in my country. I tried to tell him I was afraid, but he did not listen. He called me lots of bad words. I spent one day and one night in the Hilera before they transferred me to GEO in San Diego. I suffered in that detention. I suffered so much discrimination. I wasn't with the people of my identity. I was with men. I was cold and hungry and depressed. I suffered so much discrimination from the security of the detention center. I didn't go to immigration court. I only went to federal court. When I was fighting against those during those 4 months in federal detention, going to federal court and not immigration court, was so that I could go to fight my asylum case. It wasn't that I was fighting my asylum case already. I was fighting to be able to go to asylum court. I spent 4 months locked up so that the judge would give me the opportunity to fight my immigration case, but he did not. After 4 months of being in San Diego, they moved me to another place, to another detention center. On day 15, more or less, I don't remember because they don't have a calendar or anything because we were locked up, a security guard arrived in the middle of the night saying, "Get up, get up, get up." I told the guard, "I can't leave. I'm fighting my asylum case. I can't return to my country." No one asked me if I was afraid to return to Guatemala, but I told them. I begged the people from ICE and they didn't listen to me. I told them part of my case in front of everybody, but they didn't listen to me or even respond. I was put on a bus and sent to the airport. We were handcuffed at the hands, waist, and ankles. We were on the bus for hours. We hadn't eaten anything. We finally boarded the plane and I kept asking to talk to my lawyers. I was told that calls are not permitted and that I was being deported. They sent me back to Guatemala, even though I was afraid and even though I never saw an immigration judge. I was set back in chains.
So Alexiss suffered horribly in detention, and I'm just going to close with this story, and actually ended up having a little bit of a happier ending. So because Alexiss was actually quite involved in NIJC, we represented her in a couple different matters. We actually were able to negotiate with the government to bring her back, and which they never, ever do. This is a super unusual situation. And she was just really lucky that she was in a situation where we were in a position to do that, essentially, I think, threatening to make a very public scene about it in order to get them to let her come back so that she could actually ask for asylum. So, and the other reason that she was lucky is that she remembered her attorney's number. So she was able to call when she got to Guatemala, and I believe that we were able to connect her to a safe house so that she could wait there while we negotiated to get her brought back to the US. Because essentially refusing to let somebody even have a credible fear interview when they assert fear is like blatantly illegal and against the regulations. And so so she actually is in the US right now waiting for a hearing to be scheduled so that she can ask for asylum in front of an immigration judge. So I think now that's kind of the summary. So we're going to talk a bit about how you can help. So what can you do? So as Mary Meg and Ellen noted at the beginning, NIJC is involved in all sorts of different advocacy modalities. We work in DC on the Hill. We sue the government. We provide direct services to people. But all of our work is only possible because of our supporters. And you all can help in really, really tangible ways. And so somebody had actually asked in the chat why Oliver wasn't subject to MPP. So I don't know if everybody's familiar with MPP, but it's basically, MPP is an acronym. The government calls them the Migrant Protection Protocols. We call them the Migrant Persecution Protocols, but it's a program where people are asked to stay in Mexico while they're going through immigration court proceedings. And it's one of basically many attacks on the asylum system and many different efforts of this administration to really curtail asylum by, first of all, changing the substantive law of asylum, and then also creating these different basically administrative processes that they can channel people's cases through to make it feel as difficult as possible to fight their cases. And so the reason that Oliver wasn't put into MPP is a little bit of a mystery to us. They don't put everybody into MPP. We've mostly been seeing family units be processed through that system. But even as MPP was ramping up in the Tijuana and San Diego area, we still saw a number of people who were crossing and being processed through these kind of more traditional expedited removal and reinstatement cases. And so we have had very little overlap between MPP and this federal prosecution system. To date, I think that may change as things develop. But the reason I did want to bring that question up now is because basically this ramping up these federal prosecutions to make people face actual jail time, get an actual criminal conviction for crossing the border, in addition to deporting them and making it really hard for them to ask for asylum and other forms of relief, is one of that kind of menu of options that the administration has created to really restrict asylum and to restrict just basic like due process rights at the border, whether or not you're asking for asylum or not. And so one of our action items is basically kind of in that vein. As the administration is looking towards the election, they've set forth a number of different proposed rules to amend the regulations that govern how asylum works. And basically all of those proposed rules have really been narrowing asylum. So the most recent one, there was quite a big effort to ask people to submit public comments opposing the last rule, but there's actually another one on the horizon that would essentially use the COVID-19 pandemic as a pretext to prevent people from asking for asylum. And it's a pretty poorly disguised effort to try to exclude people from the country on racist assumptions about public health. And that's been happening since forever in the immigration system. So this is not a new tactic, but it is a really disturbing one, especially considering how much the US's deportation policies have actually contributed to the spread of COVID-19 across the world, and particularly in Central America. So this is basically, so there is this proposed rule. There is an opportunity to make your voice heard. Anybody can submit a comment. You don't have to be a lawyer. You don't really have to understand what it is, but so that you can understand what it is, NIJC does, I believe, have a comment portal on our website to kind of help people do that. So that's one thing that we're asking folks to do, and I'll turn it over to Jesse to talk about some other stuff.
Thanks so much, Dorian, and thanks. Yeah, so someone in the chat mentioned, you know, actions. What are some of the actions people can take if they're not attorneys? So there's a resource that Ellen will send around, and that of course looks at different ways people can help. Volunteer language services is a really important way, providing language support for people detained. For attorneys, as was mentioned, attorneys can look at NIJC's current case list, where there are about 72 cases in need of representation. You know, a lot of these people, of course, include individuals who have gone through these prosecutions. And as Dorian mentioned, submitting a comment opposing the latest proposed related to asylum. Contacting members of Congress. There are resources to direct people to NIJC's website and to advocate for Congress to make, which has the power to cut off funding, to stop mass incarceration and family separation, and can curtail the enforcement programs that lead to these prosecutions that we're discussing today, as well as lead to incarceration and deportation. So we'll be sharing around that material, and look forward to hearing questions.
So I think we are going to open it up to questions, and there are a few in the chat. I think that somebody has been collecting them.
Thank you, Dorian and Jesse. I'll hop in now. This is Jordan Rosensky, and we do definitely have some great questions that are coming in. And one of the questions that seem to be coming up the most is, what exactly can we do now? And, you know, how can I help? Do I need to be, what can I do if I'm not a lawyer? So I want to remind everyone that we do have some handouts included on the presentation that have more details about next steps that you can take. And one thing that you can definitely do is we encourage everyone to submit comments on the asylum rule. You definitely do not need to be a lawyer to do that. And we definitely appreciate you following up and asking more questions about that, and we'll let you know how you can help. So some other questions that are coming in, a couple questions about Lewis's sentence, and one question, Jesse, if you maybe want to answer, was, how is it that Lewis is serving a 6-year sentence for reentry? Is a 6-year sentence a common punishment for reentry?
I think so. Yeah, a 6-year sentence it's a pretty high sentence, but Luis had prior criminal convictions. They're relatively minor things, but regardless, any prior criminal record, regardless of what took place, and regardless of whether they served out that sentence. So Luis had already served that sentence. That was done. He had been basically deported because of prior interaction with the criminal legal system. And so then, and he returned also multiple times to try to come back to be with his family. And so in combination, because of these prior criminal interactions, and because of trying to come back multiple times, this is why the judge added such a heavy sentence. So people with these type of records, it is quite common to have a heavy sentence to actually spend this much time in jail.
Great, thank you, Jesse. Another question we had was about Oliver's case. Is it legal for ICE agents to arrest an individual in the same way that they arrested Oliver? Dorian, are you able to answer that?
Yeah, so that's a great question, and it depends on the situation, is my very lawyerly answer. So most people who are apprehended along the southern border are actually apprehended by Border Patrol. They're basically authorized to operate in the 100-mile zone from each of the land borders, and they take the position that that also goes to sea borders, which is the vast majority of the population centers of the U.S. And so they have authority to do that, and they essentially have kind of carte blanche to arrest anybody who they think has crossed. ICE, ICE has pretty extensive surveillance and arrest programs across the country. I have had a few clients who were arrested by ICE in the border area and away from the border area. Essentially, they take the position that once they have identified somebody and they believe that they're here in violation of immigration law, they have the authority to arrest those folks. And I guess I would add, there's been a lot of attention on this recently with DHS's heavy involvement in repressing dissent in Portland and in other places. And I think as somebody who's worked on the US-Mexico border doing immigration defense work for a very long time, this is really nothing new. This kind of treatment and targeting and really like scary militarization, people in like full like army gear, beating people up, harassing them, insulting them when they get arrested, refusing to tell people what agency they're from. It's actually been kind of standard operating procedure along the border, and especially against communities of color here for a very, very long time. And it has also been standard in immigrant communities across the country. I know that over the past several years, as various local law enforcement agencies have decided to stop holding people after they were supposed to so that ICE could come pick them up, ICE has started doing home raids, as has happened pretty extensively in places like New York. Well, they'll come in like full SWAT gear at like 4 in the morning and lie to people to get access to their houses. These practices have been quite well documented. The Immigrant Defense Project is a nonprofit in New York that has done a bunch of documentation of these raids. And so that's a very, very long answer to this question, but I think it's worth highlighting the ways that all of the authority, all of the kind of entitlement to acting in kind of nefarious and sketchy and potentially like in ways that feel very unconstitutional and very illegal. All of that is quite connected to the ways that the law actually does provide for DHS to implement these really like terrifying policies on people on the basis of their citizenship, or sometimes even on the basis of mistaken identity. We've had a number of stories of people of ICE like racially profiling somebody and being like, oh, well, he looked like the suspect that we were actually looking for, but it turns out this guy is also not documented or also returned after deportation, so now we're going to arrest him and charge him for 1326. So it is what happened to Oliver is not unusual or illegal. It's quite standard.
Thank you, Dorian. Just a reminder, if I see a couple of people with their hands raised, the best way to ask a question right now is to put it in the question box, and we'll make sure to answer it there. Another question is, are there any paths to citizenship for people who are prosecuted under 1325 or 1326? Jesse, do you think you could answer that one?
I could start and then pass to Dorian. And the prosecutions don't, this is also, I think, another complicated one. They don't necessarily block a person's pathway to citizenship. but of course make it more difficult. I think Dorian can add more.
Yeah, so that goes less to like the actual impact of having a conviction, and more to like kind of other pathways to citizenship for people who are crossing the border or who have prior deportations to begin with. And the answer is, for some people there are, but for the vast majority of people there aren't. So if you're in expedited removal, you pass your credible fear interview, you end up winning asylum before a judge, that's a pathway to citizenship. But anybody who has a prior deportation and is put into that other process called reinstatement, even if they can get relief to prevent them from being deported to their country, that basically like the way that relief is structured doesn't permit you to get citizenship in the future. There are a couple forms of relief where there are waivers for like certain conduct, like crossing the border. So I have a client, actually another client who's featured in the report, who was the victim of a violent crime here in the US a while back. And so we actually represent him in a U visa, which is a visa for victims of crime who have cooperated with investigations or prosecutions in the US. And so for him, that particular form of relief has pretty broad waivers in regards to your past criminal history and also your past immigration history of deportations or just living here without papers. And so in his case, if it ever gets decided, and there's about a 10-year waiting list right now for U visas. So once he actually finally gets to that point, if he actually is granted the visa, then he'll have a path to citizenship eventually. But it's going to take quite some time, and he's really in the minority of people. So most forms of immigration relief are basically precluded if you have a certain number of deportations or certain criminal convictions in your past, or have like lived in the US for a long time and then gone back and forth a few times. So it gets kind of complicated, but that's one of my jobs, is to figure out if there is something for our clients to do. So we've definitely been exploring all of the different options for people. And I guess I would just note, one of the kind of onslaught of proposed amendments to asylum law that is actually under consideration right now, the comment period is already over, actually explicitly says that a 1326 conviction would be a bar to asylum. And it also makes a 1325 conviction, that improper entry conviction, an adverse factor in the kind of discretionary part of asylum. So even if you're eligible, the judge still kind of gets to decide if he wants to give it to you or not. And if this new rule goes into effect, then that improper entry conviction will be a factor weighing against getting asylum. So they're really using the power of the regulatory state to restrict the possibilities for folks.
Great, thank you, Dorian. We have a great question here, which gets at some of the confusion between what is a criminal offense and a violation of the Civil Immigration Code. And the specific question is it a criminal violation to be in the country after a visa has expired?
I would have to look at the improper entry statute again. I don't think it is, but there might be a provision of it. Maybe we can ask another question. I can Google it in 30 seconds. I'll be ready to answer that one.
Great. Let's see. And just as a reminder, you can keep putting your questions in the question box. We're getting a lot of really great questions. So one good question is, what would our immigration system look like without 1325, 1326? Jesse, do you think you could take a stab at that?
Yeah, so as you know, really went through how the system works and how essentially when someone is referred for prosecution, they end up in the same place as when someone is not referred for prosecution. So they still are shuttled into the civil immigration enforcement process. And so essentially doing away with these prosecutions for illegal entry and reentry would just leave the civil immigration system intact. So people would still go through the process. They would still be detained at the border. They would still go into Border Patrol custody. They would still go to custody of the Department of Homeland Security, still go into ICE detention. All of these things that are incredibly problematic in and of themselves, and people, of course, done an enormous amount of advocacy to change that system, as NIJC does. That would still be intact. So all it would do is get rid of this criminal structure. So it would just, people would not go through this kind of system of double punishment. They wouldn't be prosecuted in the criminal system and then also go through this immigration, the civil immigration system.
Yeah, and I would add to that, the other thing that it would do is it would end the system of double punishment, but it would also be a pretty serious financial hit for the private prison corporations that run facilities that are specifically built to house people who are serving their sentences for these crimes. So especially the longer term 1326 sentences. And then I guess to go back to the last question, overstaying a visa is not a criminal violation. These statutes both explicitly criminalize the act of entry without authorization. So that would just be a civil violation if you overstayed your visa. And it would subject to somebody to like being open to deportation proceedings, but you can be charged in federal criminal court for that.
Great, thank you. We have a couple of questions that have come in about the proposed asylum rule and the best way to enter a comment. So I just wanted to remind everyone that we do have that link directly in our handouts, and we'll send it out afterwards. And we do have a great guide to how to submit your comments. So that could be really great. One question that I had that I don't know the answer to is, can non-American citizens help? Can they submit a comment? Jesse, do you know the answer to that?
Yeah, non-citizens can submit a comment. NIJC has worked with also with clients, people who have gone through you know, a lot of these the processes to actually to submit their own comments to really explain how drastically these changes would impact you know, their cases and people who have similar cases. But yeah, it is open to non-citizens.
Great, thank you so much for that.
Before we go to that final question, Jordan and everybody, this has been really exciting. I just wanted to jump in also and say that, you know, as our time is running up, not to forget that we will be back in about a month on the 1st of September. And we hope that you can join us and stay tuned for our, you know, as we define that topic, as things change so quickly, we will be defining that topic in the upcoming weeks and make sure to give you the most updated information. And also this QR code here is important because it gives us you will be sending a link to the survey. It's simple 4 questions, but we would really appreciate your feedback here. So I think we have time for one more question, if we have one, Jordan, and then we'll wrap it up to respect people's time.
Yeah, I think for the sake of time, we can wrap it up right now, unless anyone wants to send in one last question. But I think we have about a minute for Dorian and Jesse to offer any final words before we sign off.
I think my final words are that, I mean, there's all of these things that you can do, and it's been really encouraging to see so many people paying attention to these issues. I first saw Operation Streamline in 2009 when I was in college, and I still like have such a vivid memory of that. And I like, this has been happening for years, and it's really exciting that NIJC has committed resources to the San Diego project, both because I have a really cool job, but also because this is a population that is really underserved. But I would say, if you're not a lawyer and if you don't have translation skills, like doing things like submitting comments might feel kind of silly, but it actually makes a really big difference. They have to read every unique comment that they get, and so if nothing else, it can delay the process and help a couple other people pass through. while we're waiting for it to be implemented. And then also really like this is an issue that has been construed as like kind of radical by the media and in the political discourse. And I think it's really, really important to just remember the humanity of the people who are being impacted by it, and talk to your Congress people. There are groups doing really amazing work to advocate for these statutes to be repealed. And so please get engaged, call all of the people. And thank you so much for being here. Jesse, do you have any final words?
Yeah, thanks so much. And thanks to Dorian. I mean, the work out in the San Diego office and that NIJC does is so pivotal and so important, and bringing that work into the policy advocacy in DC has really been critical. And as Dorian said, raising the awareness for members of Congress of what's taking place and how these prosecutions are functioning and is incredibly important. So again, grateful to all my colleagues and grateful for everyone for tuning into this.
Great. Well, thank you, and you have a lovely rest of your day. Bye-bye.